Hello and welcome to your next flipped lecture. We'll be talking about your criminal rights, otherwise known as rights of the accused. Everything you should know about if you're ever accused of a crime or stopped by a police officer, anything like that. Okay, so there's a number of amendments that we need to talk about when we talk about criminal rights and the rights of the accused. The first one is the Fourth Amendment, which guarantees the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. That's the key phrase there. Unreasonable searches and seizures. Simply put, the government cannot seize anything from you without probable cause or really good reason, or other steps must first be obtained if they are to do that. Think of the Fifth Amendment, which says that no one shall be compelled in any criminal case to be a witness against himself. We think of in court dramas and other movies where people are on trial, when asked a question, they say, "I plead the Fifth." And this is what they're talking about. Meaning, if you're accused of a crime, you do not need to take the stand and speak against yourself in an incriminating way. There's the Sixth Amendment, which says that which guarantees a defendant, someone accused of a crime, the right to have the assistance of counsel in his defense. Otherwise put, you have the right to an attorney, a lawyer. And we get this from a very important Supreme Court case, Gideon versus Wainwright, which we'll talk about later. There's also the Eighth Amendment, which forbids cruel and unusual punishments. Here we see the lethal injection, firing squad, and electric chair. Oftentimes, when we think about the Eighth Amendment, we talk about capital punishment, the death penalty. And then there's the 14th Amendment. Now, we usually think of the 14th Amendment in terms of it setting up citizenship for former slaves, as it is one of the civil rights amendments, Civil War amendments. However, there is another important part in the 14th Amendment that guarantees everyone the right to due process. And what that means is that government must follow proper procedures to take away your life, liberty, or property. What does this mean? It means that the government cannot just arbitrarily, on a whim, take away your, kill you, take away your liberty, put you in jail and not allow you to be free, or repossess any of your property without proper procedures first being followed. And so we'll be talking a great deal about searches and seizures. We're talking about the Fourth Amendment. So what is considered a search? Well, some examples are searching your home. When a police officer comes to your house with a warrant, saying we have a warrant to search your house, they have gone through the proper procedures to do that. A drug test is a search of a person's body, searching to see if there's any drugs present, currently or in the recent past. Or wiretapping, also tapping the phones. So the government listening in on your phone conversations because they believe that you are part of some kind of criminal action. And so there's four areas that are protected by the Fourth Amendment: person, home, papers, and effects. So, the government, the police cannot just attack you. They cannot seize your body or search your body as they want. They can't search your home without going through proper procedures. And then when we think about papers, we think of letters, emails, any kind of documentation that is important to you. And then effects. Effects really mean just property. So, it might be a laptop or anything that you might own. Of these four, your home, in terms of searching, is often regarded as the most protected. So when we're talking about this, we often talk about a warrant. Well, what is a warrant? A warrant is a document obtained by police after stating under oath that they have probable cause to suspect someone of committing a crime to justify a search. The key phrase here is probable cause. How does the police determine probable cause? Well, they have to go in front of a judge to obtain this warrant. And the judge is going to ask these police officers what evidence have they, compiled that leads them to believe that there's something of uh, illegal sense in maybe their home, their car, what have you. And if the evidence is convincing enough, well then the judge will give the warrant. Without it, the search cannot be done. However, there are special circumstances when a police officer can search without a warrant. If a person commits a crime in police presence, if you're walking down the street and you hit someone in the face and a police officer sees that, they're going to search you for things that they think might be illegal. Seizure of drugs during a traffic stop for minor traffic violations. If in the course of stopping you, say for a speeding violation, you give them probable cause to think that there might be drugs on your person or in your car, and that could be a legal search. Drug testing of workers. Workers cannot say that it's an illegal search because in most cases it's not the government doing the searching. However, that drug testing can be a condition of employment. If it's in plain sight, if this illegal substance is in open view, whether that be, the window of your house or from the window of your car, that gives the police the probable cause to search your car or other places. If there's not enough time to get a warrant, or if it's found during pursuit. So if police are chasing you down and something is found during that chase that otherwise wouldn't under search and seizure protections, then it is illegal. The next thing that we think about that's very important is the exclusionary rule. What the exclusionary rule means is that any evidence obtained illegally cannot be used in court no matter how incriminating. That's important. If, say, the police, beat you up and get a confession out of you, well, they've violated your rights by attacking you, and that confession cannot be used in court. However, if police have acted in good faith, the evidence may be used. Also, if the prosecution can prove that the evidence would have been discovered by legal means, it sometimes is allowed. So for the most part, if evidence is not obtained legally, cannot be used. However, there are some exceptions. We think of the case California versus Acevedo, which determined that police may search automobiles and containers in cars if probable cause exists to believe that contraband or evidence is contained. If you're stopped for a traffic violation and the police officer has reason to believe that you might have drugs in a car, they might then call over a canine unit, have the dog sniff the air. Because ultimately the air is open to everyone. And so if they detect the smell of marijuana in the trunk, then they do have probable cause to search that trunk. Now we think of searches in schools. This is very important for students. In a very important Supreme Court case, this is one you're going to want to know, New Jersey versus TLO, it was determined that school officials do not need warrants or probable cause to search students or their property. Otherwise put, police officers need a very high threshold of evidence to determine probable cause and to do a search. However, in a school setting, school officials only need reason to believe that a student has broken school rules in order to justify a search. Very different thresholds. Additionally, drug testing for student athletes was upheld by the courts, saying that extracurricular activities such as that are not required in order for you to be in school. Therefore, that you can be put under that drug test. The other thing I'll say is that whenever you see initials like this means that it's a court case that involves a minor. That is that person's initials. So that's very important. Wiretapping. In order for the police to wiretap your phone, they must have a warrant. However, the Patriot Act, which was a law that was passed in response to 9/11, has pushed the limits to expand the security. Now the government can wiretap your phone if they suspect you, if they have reason to suspect that you're engaging in terrorist activities. Judges examine Fourth Amendment cases by figuring out who made the search and seizure. Was it a government official or was it a private person? Government official has to go through many hoops than a private person does. They have to determine were the individual's rights violated. Was there probable cause? Was the warrant executed and carried out in good faith? And does the exclusionary rule apply? Then we think of fair trial. In the Fifth Amendment, there's the part that says you are not subject to double jeopardy, meaning you cannot be tried twice for the same crime. Protects people from harassment. Government can't just try you over and over for the same crime because the jury the first, second time didn't like it. However, there are exceptions. It can be tried in state and federal courts if state and federal laws are violated. An example is the Michael Vick dogfighting case. He broke both state and federal law, so he was tried twice for the same crime. Some other exceptions is when a single act involves more than one crime. Another one is when a jury cannot reach a verdict. A jury needs to make a unanimous decision one way or another. If they don't, it's considered hung and has to do a retrial. Or when a defendant appeals to a higher court. If you're the defendant and you don't like the outcome, you can always appeal to the higher court. Doesn't necessarily mean that your case is going to be heard, but this is an instance where the same case is going to be tried twice. We talked about I plead the fifth, the right against self-incrimination, saying anything that would hurt yourself. You cannot be forced to testify against yourself, and confessions must not be a result of force. We think of our Miranda warnings. 1, the right to remain silent. 2, anything you say can be used against you in a court of law. 3, the right to have an attorney present during questioning. The right to an attorney if you can't afford one, and the right to bring police questioning to close at any time. When we watch police movies or any kind of TV shows like that, we often think of these. These need to be read to you if you are handcuffed. The right to due process is in the 14th Amendment, as we spoke of. We also think of the burden of proof, the phrase that you are innocent until proven guilty. The government must prove that you are guilty. You do not have to prove that you are innocent. It is on the government's end that they have to prove that. We think of ex post facto law, which says that the state cannot get even with a person by enacting a law to punish the individual, meaning that something you did cannot later on be declared illegal and then the government retroactively coming after you. That's not allowed. The government cannot make something illegal after the fact. The Sixth Amendment is a right to a speedy public trial by an impartial jury, meaning a jury of your peers that are not biased. You have the right to counsel a lawyer, is what that means, and that was upheld in the Gideon decision. Gideon versus Wainwright. He was denied a lawyer even though he couldn't afford one. And we're back. So a lawyer must be provided to you if you cannot afford one. In 1974, it was decided that a speedy trial means that it must happen within 100 days. The trial must be open to the public. We want this because we don't want trials that are secretive or whose results we don't understand. That the trial must be by an impartial jury of your peers, 12 members in most cases. You must be informed of your charges. The defendant has the right to questioning and cross-examination to those who testify against him or her, and that the court can order a person to testify and give evidence in a case. This is what we call a subpoena. It's an official court order to appear. Eighth Amendment forbids excessive bail. Bail is a property or money given as a surety that you'll show up. It works as a preventative detention if you are considered at risk of violating another crime. You're innocent until proven guilty and can better prepare outside of jail. Punishment avoids unnecessary infliction of pain. And death penalty was ruled unconstitutional in 72, reinstated in 76. 38 states have it, and those are the 5 methods by which you can be executed. Thank you.